He submitted an application to NERSA for the approval of the tariff reduction and the PPA, and the application was supported by the IPP office by sending the approval letter. The energy regulator considered and approved the application on 10 November 2021, and the applicant then reached financial close on 1 May 2022. When the applicant submitted the amendment PPA for Eskom to sign, Eskom picked up that there were errors on the starting tariff, of which the 1.2% tariff reduction was applied in the IPP office approval letter. A request was then made to the IPP office to correct the letter, and the corrected letter is attached as Annexure A. It should be pointed out that the refinancing model that was submitted to NERSA was correct. The only problem is they applied the 1.2% to the wrong 2011 tariff. The requested changes will ensure that Eskom signs off the reduced tariff in the PPA, and the applicant is benefiting from the reduced interest rates from the lenders under the refinancing arrangement. Eskom and customers are, however, not benefiting since the PPA have not been yet amended. It is requested that the Electricity Subcommittee approve the corrections on the recommendation on page 5 of the submission. Thank you, Chairperson.
Thank you, Ms. Mkhwanazi. Very well presented. Much appreciated. I think the issues are clarified. Members, there is the submission before us. Any questions, comments on the submission? The show of hands, Madam Assetti.
Thank you, Chairperson. Chairperson, at the beginning, I was trying to figure out the nature of the error here and where the error originated, where it emanated, whether it emanated from our side, and whether that, if that then was going to change the decision itself. And it appears to Mr. Somebody's mic is on and somebody's talking in the background.
Mr. Lamine, it's your mic.
Thank you, Chairperson. So, Chairperson, it appears that this error, yes, it originates from the IPP office, and then it comes to us, and it seems that we have to do a completely different calculation because of that change, and we calculated something different based on the information that was before us. And this time around, we are asked to calculate based on a different figure. I was wondering whether then this is a completely new request or is a correction in the true sense of a correction. That's number one, so that we can get this right. Then the second thing is that perhaps when we deal with these matters where we need to correct, it is important that we clarify the legal basis of correcting a decision that was already taken, or at least correcting an error in the decision that was already taken. It's important that we always put the legal basis for it, put the jurisdiction, whether the energy regulator can do that, and on what grounds, and what is the authority that we have. It is always important because our law states clearly that once we have taken a decision, we cannot change that decision. And I'm saying this not because I'm not aware of the fact that with the request that is before us, we are not necessarily asked to change a decision, but we are asked to check whether indeed there was an error in our decision. whether that error is a factual one and is an error in law in terms of our decision. So, and where that error emanates, and be able also from our side to satisfy ourselves that at the time of taking the decision, there was this error. And that is what we need to do during our assessment. It is not a question of just saying that this somebody picked it up elsewhere and it is the information that was not before us at the time, such that with the information that was before us, we did the calculation. But now it appears that there's a completely different figure that is now put into the work, and now we need to do a recalculation based on new information that re-emerged. And one could then argue whether or not that is an error with the information that was before us at the time of the decision. So I think those things, for me at least, they become important. And I say this because based also on the preparation that I've made and checking some of the cases and several judgments, and when a body that is required to take a final decision that cannot be reviewed, and that body then needs to make sure that it establishes jurisdiction in terms of correcting errors. So that is the basis of my question, Chairperson. Thank you.
Thank you, Madam Massetti. Advocate Sithole?
Thank you, Chairperson. Mine is just an issue of clarity, which is based on the assumption that the effective date of the correction will be today, which is the 5th of July, 2022, after the subcommittee has approved or have considered and made a decision on the application. And I see in the submission, it stated that the financial closure between the applicant AEAMD and its lenders was reached on the 1st of May, I think, yeah, but in May 2022. And I just want to get clarity, when does the benefit that the applicant is supposed to be getting, when does it kick in? Is it May or is it now in July 2022? Thank you, Chairperson.
Thank you, Advocate. Mr. Mkhize?
Chairperson, I'm partly covered by my colleagues, but maybe just to properly put forth some of the issues from my side is that I think that in terms of the subject, to talk about correcting the tariff reduction, maybe there's a proper term that must be used. This gives us an opportunity to really look at this and really follow the book exactly, so that it sets a precedent. It's not so hard under the current economic conditions when one talks of lowering instead of increasing, but it could have gone either way. And for that, we must make sure that we adhere to the proper legal principles, and therefore the need to outline that, to say, what exactly are we doing here? If someone has made a mistake, then applies, and then we approve, then comes back and says, I've made a mistake. What is the right thing actually to do? If, for example, this was already in place, would it then be applicable retrospectively, the correction, or the correction will only apply going forward? I understand here that the projects are still being developed, but just to look at that, so it's all encompassing. It serves also as a reference point in terms of, or a precedence in terms of future decisions. Also, to properly define the nature of what we are doing legally, as also Madam Massetti has highlighted. For me, that would be important. And also, there must be a clear demonstration that we have also perused these documents, we verified them somewhere if there's a place of verification. So you don't just say that the IPP office has found that and now they've changed, they come up with a different figure. Then what if maybe there's still some other Kremlin somewhere that they did not pick up? What then will you do next? That is all from my side. Thank you.
Thank you, Mr. Mkhize. Okay, I see now Mr. Siamela is now connected properly. Over to you. I'll start with you, Mr. Siamela, but of course, you can indicate whether you still need input from Mr. Mkwanasi. Over to you, Mr. Siamela.
Good morning, Chair. Can you hear me?
Loud and clear.
Yeah. This time around, it's not a question that the energy regulator has made a wrong decision. The IPP office made a mistake in terms of the base of the tariff. Now, what the applicant did, he went back to the IPP office and said that you used the wrong base. Please correct it. Now the IPP office agreed to correct it. Gave us a letter to say that no, we need to correct the tariff because the base was wrong. So we're bringing it back here to actually get it approved with the correct base. So it's not like the energy made a wrong decision. That's not the case. The IPP office made a mistake in terms of using the wrong base. Not NESA. And Ms. Mkwanasi, you can support me in this regard.
All right. Can I, Ms. Mkwanasi, can I guide here? The issue here is the legal basis. So if the regulator has made a decision and you're coming for a correction, would the regulator be correcting its decision? Is that allowed? So if we can also, Mr. Murati, if we can weigh in here, because the issue here is more the legality of the decision and what does it mean? Correcting, what does it mean? Although the error may have come up somewhere else, is this a new application in respect of this particular issue? Is it a resubmission of basically a new application? So that is the issue here. It's the legality of it. That it's not the fact that the error originated with the IPP office, and it is the IPP office that is also initiating a correction. The question is, does this not amount to the regulator revisiting its decision? That is the question. Mr. Siamela, maybe if you can address yourself to that, and maybe I am assisted by Mr. Murati, because that is the legal question that the colleagues are asking.
Okay. In that regard, may I call Advocate Murati to come in? Thank you, Advocate.
Thank you, Dennis. Morning, Chairperson, and morning, members and colleagues. Chair, I think there are some fundamental errors in the format of the submission. In that, this concept of error, it needs to be made very clear where the error is, and I think Dennis outlined that the error actually occurred outside of the regulator process. And what was brought before the regulator was a valid application, which the regulator applied its mind and took a decision. And that decision remains valid. So it can only be amended, can only be changed by another application. It cannot be changed on the basis that there was an error. The error is not on the decision of the regulator. The error occurred in the application. So to remedy the situation, another application to court to change the decision needed to be made, not in a format that the regulator is being requested to correct the error. There is no error on the administrative action taken. Thank you, Chairperson.
If I can then request, what do you suggest then? How do you suggest that we process this particular application then?
In a simple way, it should have been an application that would have been brought to say this change, to outline everything that Mr. Siamela has highlighted in terms of where everything was missed and how the application ended up being submitted on the basis of an incorrect information. So it should have been an application. It should be an application that is being made.
Right. Mr. Siamela, I noted your hand, Madam Maseti, but Mr. Siamela, is this a new application, or are we now revisiting our decision?
Chair, as far as I'm concerned, as much as Advocate explained it, the only way that it can be corrected is when another applicant comes in. to correct the previous decision. But the correction is not so much from the energy regulatory decision. It's from the IPP office. Remember, Chair, that all the projects that are being controlled by the Department of Mineral Resources and Energy, they come through a Section 34 determination, and they were bound by the Section 34 determination. That's what Mr. Murat will talk about that one.
Okay, I'm not sure you're actually hearing my question, but nonetheless, Madam Massetti, you have a follow-up, ma'am.
Chairperson, I am partly covered by Mr. Murat. I think he explains it very well, because he knows very well how one will deal with errors. This has nothing to do whether somebody else has picked it up. In fact, with other legislation, they will even give you timelines within which you can bring. Once you become aware of that error, sometimes you will even be given 20 business days so that we can understand whether there is a delay or the reason for the delay in you picking up that error and bring it to the body that took the decision. So that doesn't matter, Mr. CML. The fact of the matter is that even when that body has jurisdiction in correcting an error in a decision or an error in its judgment, it must satisfy itself that it is indeed an error, and where that error emanates, and whether then having this error, whether this body has jurisdiction to correct that error. Mr. Morati puts it very well, and in the same way that I have also clarified it earlier on. Now the question here is whether that information that you're saying is now quite new in a way, because if that information was not submitted to the regulator at that time when the regulator assessed the application, the amendment application, and when it took the decision, two things. If that information was not before us, how do you then say it was an error? Because that information somehow it was there, it was submitted, but something went wrong. Whether that thing it went wrong, maybe they forgot to mention something. The fact of the matter, that information was never submitted. So they are submitting completely new information, and they ask the regulator to recalculate. So that is the issue, and therefore it calls on us on whether or not we need to now characterize it as a correction of an error in the decision. That is the issue, Chairperson, that we need to deal with, and we need to get this right. Because if that information was not before us, maybe that's where Mr. Morati must come in. If that information was never submitted to the energy regulator, number one, and it was not before us, was never known to us at the time of taking the decision, it was withheld elsewhere, how do we go about it? And by the way, there are high court cases that deal with that particular issue. Judges express themselves when that information was not before you, and what was the reason when that body did not have that information at that time, and how do you deal with that? Thanks, Chair.
Thank you, Madam Massetti. Mr. Mkiza, follow up, sir.
Thanks, Chairperson. I think, Mr. Siamela, as you responded, well, from where I'm sitting, I'm clear that the mistake is not on the side of the regulator, and that this is also not talking to the error in the decision. It's talking of the error in the documents submitted to the regulator, therefore taking the decision based on what was before itself. So now it's not an error in the decision, but it's about how the submission is crafted to convey exactly that. And another thing that comes to question that is, if today I apply for a tariff adjustment or a price to be set, I apply today, I get new information tomorrow, then after a month, I apply again now using the new information as a new license. What prevents me from doing exactly that? Because I have applied, yes, a tariff has been set, new information has come up. I apply again because there is no time limit in terms of how frequent I can apply. So I was hoping that this submission would talk to such things, because there's something, I mean, in my understanding, there's something that tells me that no, you can, this can just be a new application citing the previous one as to what has happened, but it's just for information and for background. But actually, nothing precludes me from launching a new application based on the new information that I have at a particular time. So those are some of the things that I was thinking that legally we'll talk to, and also from the side of the technical team being able to verify all of that and really satisfying itself that the information is correct, that it is indeed exactly like that, and putting some kind of verification there too. I don't want a chairperson to talk a lot on this and then delay the meeting and then end up not actually approving or making a decision on this. Seemingly, there is this challenge of the legal argument, and now legal arguments are being put at this platform, when I think that the team would have done a better job by engaging us outside of this meeting and bringing a submission that is actually legally sound. Because I think for all of us, let's just be aware that as a creature of statute, the first point of call is the legal basis on which we do things, and how then we do those things, or how efficiently or effectively becomes now the next steps. But the first and foremost is the legality of what is before us. Thank you.
Thank you, Mr. Mkhize. Thanks, Mr. In guiding the decision going forward, as you respond, Mr. Murati, can I pose a direct question? Because this, out of this question, then we'll then be able to see how we take the process forward. Can this application, in your opinion, be deemed to be a new application?
I think let me just highlight the blind spot to this issue. It's probably for efficiencies and effectiveness of our decision making, that the regulator decisions are based on what is submitted or presented before the subcommittee, and the language used in the submission is that of requesting a correction of the application. An application cannot be corrected in the subcommittee. An application can only be corrected before the decision is taken. And in this instance, the regulator is sitting with a decision that has been taken. And the format of the submission, the regulator will now have to probably, the lawyers always say, the regulator will have to talk from the bar. The regulator will have to change the language of the application, which will be irregular on its own, for it to say, we see the problem, but because the application is not in that format, we will talk on behalf of the applicant and correct the application so that we can dress ourselves with the powers to can take a decision. That will be irregular, Chairperson. The submission needed to present the correct facts of what is being brought before, that the application is being made in terms of amending a decision that has been made, which is in terms of, it's a condition of that license. It should follow what Section 16 provides, that we are amending. It's an application to amend the decision that has already been taken to reflect the correct state of fact. But having used the language of it, there's an error. For the regulator to conclude on it, then is an acceptance that there was an error. And I think from what has been presented already, there's the consensus that there is no error in the decision made by the regulator. the error occurred outside and it needed to be corrected outside, and the proper application recognizing the status of the administrative action and the language of the ERA to say we bring an application to remedy an error that we have made and would want the regulator to make a new decision to that effect. Thank you, Chairperson.
Thank you, Mr. Murata. I think that's loud and clear. Before we take this decision on this, Mr. Mkhwanazi, do you want to respond to? There was a direct question from Advocate Tony. I think you can assist us with that question.
Thank you, Chairperson. The question was the assumption that the applicant has already made the financial close on 1 July 2022. Yes, they have made the financial close and they are benefiting from the reduced tariff. I'm not sure if I'm answering it correctly.
All right, no, thank you. But can you then,
sorry,
yes,
Chair,
yes,
the issue was the effective date. They reached the financial close on 1 May, not July, 1 May 2022, and we are making a decision now. So I just wanted clarity on when did the benefit kick on the side of the applicant. Thank you.
Thank you. Mr. Siamela, do you want to add to this?
Yeah, please, may I say? What basically happened, just to give a bit of background, Mr. Mkhwanazi didn't explain the full story. What happened is that, you know what, and the applicant picked up that, you know, there's a problem with the base tariff. Discussed the whole issue with the IPP office, and then the IPP agreed that, you know, the applicant can correct the tariff. But we picked it up later that, no, it can be corrected without the approval of the energy regulator. So the reason why we got this application is coming after the fact. So the CEO is correct. The applicant it's coming after the fact. They've already effected the correct base in terms of the tariff. So right now, it's basically making things right in terms of law. Unless it's like, no, Abdul can come in.
Okay, thank you, Mr. Siamela. Can I guide on this? We've been talking on this for almost 25 minutes, and I think the issue that members have raised is the issue of the law. So if I can just request that on this particular one, the submission before the regulator is incorrect. So we need to send this one back so that it is written correctly. It's an amendment, it's not a correction. But I think we do need Mr. Murati to actually have some guiding principles. I think perhaps something that you can assist us with to indicate there may well be something that you may have written before, but it could be something that would be useful, I think, for the rest of us who may not have that, and for the team to indicate when can a decision be corrected, the decision of the energy regulator, and the legal basis for that, and all of the issues pertaining to that to the correction, and how the correction, how a decision like this one, which is really an amendment to whatever that may have been submitted before, on the basis of which a regulator would have made a decision. When is that an amendment and when is it a correction? If we can get a better clarification, I think for the teams, so that at least we've got a legal basis, as something that was indicated by Madam Massetti earlier, is that we need to have, to all of us, to have to be quite clear going forward when something is a correction and whether this particular body would have jurisdiction to correct its decision, and when would that and when does it have that jurisdiction, and when would that correction need to be made somewhere else, like the High Court, in terms of a review, or be handled differently, you know. So if we can get a guidance on that, Mr. Murati, that would assist, I think. But members, I think we are all in agreement that this particular particular document, this particular submission has to then go back and be correctly written. It cannot be it cannot be corrected by the members and then make a decision on it, as been explained by Mr. Murati. So my request is that we then this submission be sent back and it be made correctly as an amendment and not a correction. And that in so doing, team, if we can then include some of the issues that have been raised by, especially something that has been raised by advocates, to clarify those issues and clarify the issues that have been raised by members. So members, by show of hands, can we then take the decision to send this thing back for a resubmission as a correct application? Thank you, Mr. Mkhize. Thank you, Advocate Sithole. I also support Madam Maseti. Would you support? Thank you, Madam Maseti. So, Mr. Mkonazi, you've got your decision. You need to send it back and then reformat it and write it properly. And actually seek a correct decision from the regulator. But please include all of the issues that have been raised by members. Thank you. So that deals with item number 6. Can we then go to item number 7? Again, hopefully, if it's and please introduce if it's because it also says a correction. If it's exactly in the same vein as the previous one, so we don't waste our time on this one. Please indicate, Ms. Mkhonazi. I assume we are still the one that's presenting this one. If it is, please indicate so that at least the members can then vote in terms of the process going forward. Over to you, Ms. Mkhonazi.
Thank you, Chairperson. It is exactly the same with the previous application.
Thank you, Madam. Thank you, Madam. So can we then, members, can we then make a decision on this one by show of hands again to treat this for item 7 exactly how we treated item 6? Thank you, Madam Maseti. Thank you, Mr. Mkhize. Advocate, would you agree with that? Thank you, and I also support that. So, Mr. Mkhonazi, please, we're actually making the same decision that we made in terms of item 6. Can we then move on to item 8? The SCATEC submission. Is Mavuso now connected? If not, Mr. Siamena, is it also still Ms. Mkhonazi presenting? Mr. Mkhize, your hand is still up, sir? Is it a lingering hand?
Lingering.
Thank you. Mr. Siamena? Mr. Mavuso, Mrs. Yeah, who's presenting this one?
Yeah, because I've got load shedding, I'm not able to see who's presenting. Ms. Mkhonazi, can you assist me here? Who's presenting the next one? I'm using your phone, Chair.
Mr. Chair, my name is Sandy Jacobs. We agreed with the team that I'll be presenting this one, if that is okay with the subcommittee.
Yes, definitely. Please go ahead. Okay,
thank you very much. This application is for generation license for the 3 project companies, namely SCATEC Kenhardt 1, 2, and 3 Pty Limited. And the purpose of this submission is to request the subcommittee to recommend the application by the 3 project companies, and the application for generation license is under the Risk Mitigation Independent Power Procurement Program. According to the delegation matrix, clause 1.1 says that the electricity subcommittee is required to recommend such applications for approval by the energy regulator and for issuing of new licenses as dedicated to the energy regulator. On the 18th of March last year, 2021, the minister announced 8 preferred bidders for under this program, and there were 3 eligible preferred bidders as well. But after further discussions, the minister on 1st of June 2021 announced the 3 applications that we are considering today. The 8 preferred bidders were approved to be issued with a license by the energy regulator on the 21st of September last year. However, only on the 10th of September last year, that is when NERSA received applications from the 3 preferred bidders. This actually resulted in the late analysis of the applications, and only on the 22nd of May this year, that's when the licensees advertised on the newspapers, and has NERSA analyzed the applications, and the applications were found to be in accordance with were actually complied with the requirements of the licensing, and therefore Appendix B is the draft decisions for both for all 3 projects, Kendat 1, 2, and 3, Pty Limited. So therefore, we request the Electricity Subcommittee to recommend to the Energy Regulator the approval of the license applications by Kenhat 1 Pty Limited, Skatec Kenhat 2 Pty Limited, and Skatec Kenhat 3 Pty Limited. Thank you, Chair.
Thank you, Mr. Jacobs. Members, Mr. Semela, do you want to say something before I take this matter before the members?
Yeah, I want to, please, Chair. I just want Mr. Sandri Jacobs to explain why is this one delayed. There's a reason it's there in the document. So I want him for the members to understand the background behind the whole thing, why it's coming in Israel today. So please explain, Jacob.
Thank you. Okay, I would like to refer members to paragraph 4.10 and 4.11. That is where we discuss all these delays. Firstly, the delay was that the 3 applications were approved by the minister and announced later than the others. And in 4.11, we actually discuss why the delay for these applications. So basically, since September, we have been sending responses to letters to the applicant to advertise to the relevant newspapers. However, we did not receive any response from the applications. From the applicant, and what we did, then we finally had to write a letter to the 3 applicant notifying them that NERSA will now close these applications. That is when then we got a response from the applicants to advertise. That's when they promised to advertise, and finally they advertised on the 22nd of May 2022. Hence the delay for these applications. Thank you.
Thank you. Mr. Semela, your hand is up. Please lower it. Members, we have the submission before us. If you can then, by show of hands, indicate if you have any questions or comments on the submission. Any question, members? Comments? Mr. Mkhize?
Thanks, Chairperson. I support the submission, but I just want to get clarity. In terms of the installed capacity and contracted capacity, is it a matter of the load factor or what with the difference there? Just want to get maybe explanation, or they are going to be also servicing other alternative clients. Just want to understand from a technical side of things. Thank you.
Thank you, Mr. Mkhize. Any other question, members? Maybe linked to that, if you can maybe just explain something. And maybe that could better explain the issue that has been asked by Mr. Mkhize. On the RFD, unfortunately, I can't. The numbers are we don't have the overstamped numbers on this one, but it's page 16 of 17. Paragraph 68. You do talk there about the capacity factor. That particular paragraph seems to refer to the table above, or rather to the text above. It seems to refer to the solar PV system. And it then makes reference that to the fact that in bid window 4, the capacity factor was between 23 and 30%, but in this particular case is 67%. Can you kindly explain that? That simply says, is that the capacity factor of the solar system, or is that the capacity factor of the hybrid system? So if you can, so it's more a technical question here. So it's linking very much to the question that's asked by Mr. Mkhize. Over to you, Mr. Jacobs.
Thank you very much, Chair. To answer the question whether the capacity factor is for both or any one of them, the simple answer there is that it is because it is for the hybrid system. And when I come to Mr. Mkhize's question, let me just get my, sorry. Sorry, Chair, I just wanted to go to the correct, yes. As we see here, the contracted capacity is 50 megawatts, and this is, and we see that the installed capacity is much higher than that. This is because sometimes the project companies, they look sort of they look forward in terms of any other possibilities that they might be involved in, as we see that a lot of municipalities now, they are going into private requesting some private companies to supply them with power. Normally it is because of that, but this was not specified by the applicant himself, but normally this is what the applicant does, looking forward in case maybe there might be any uptakers.
Mr. Jacobs, can I request that we clarify this issue properly? Because from what I understand is that the contracted capacity is, once the contracted capacity is 50, you've got a battery system that needs to be charged. So the 50 would be what is contracted, and at any given point in time between the specified times, the seller must be able to deliver 50 megawatts. Now, whilst delivering the 50, they also still need to be charging the battery, because they're not using they'll be charging their batteries, the 75 megawatt battery system. They'll be charging that also using solar. So the 180, Mr. Mkhize, from what I understand, is actually that whole system is intended to deliver 50 megawatts. But to be able to actually deliver that 50, that contracted 50 megawatts, the system itself has been configured that is going to 180 megawatts solar PV with a battery storage facility, and that system, that integrated system, is what you can guarantee 50 megawatts. So that's what I understand. But I think just to be on the safe side on this one, can we at least get the facts, colleagues, Mr. Jacobs, from the project, from the applicants, because they'll be able to actually define this properly. But that's what I understand, Mr. Mkhize.
Noted, Chair.
Thank you. With that, I'm not sure if there are any other questions. If not, can I then take members to the decision that is sought from the members? And that decision is a recommendation to the energy regulator for the approval of the licenses to the 3 companies that are listed, and I think the numbering needs to be corrected a little bit. It's under paragraph 13. So that should be the numbering. That should be 13.1, from 13.1.1 to 13.1.3, and also 13.2, which are the RFDs that are actually associated therewith. So members, by show of hands, if we can approve that decision that is sought before, thank you, Madam Massetti. Thank you, Mr. Mkhize. Thank you, Advocate Sithole. I also support. So please, with that, if we can just provide members with the update in terms of the information that was sought. The last item, members, is item number 9. Again, I have to ask Mr. Mabuso, are you available? If not, this matter goes before Mr. Brian Sichotlo. Mr. Sichotlo, if you can address us, sir. I see you're on the call, Mr. Sichotlo, so I don't know whether we've got connection challenges or what. If not, Ms. Mabinya, please assist us.
Thanks, Chair. Is Ms. Kwenamatlo who will be presenting the submission?
All right, thank you, Ms. Matlo.
Okay. Thanks, Chair. Good morning, members and colleagues. I would like to make the following corrections. On page 3 of the submission cover, paragraph 5.2b should be net contribution of AMSA to the economy and not Sublime, and D should be technical benefits of AMSA NPA agreement and not Sublime, and all the figures are confidential. On 1 December 2021, Eskom submitted the 3-year NPA with AMSA Saldanha Works in Western Cape in line with the amended framework for short-term NPA approved on 20 August 2020. The preliminary assessment was conducted for the 3-year NPA and it complies with the requirements of the amended framework for short-term NPAs. AMSA Saldanha has been under care and maintenance since April 2020. They have approached Transnet, the Western Cape government and the Saldanha Bay municipality for assistance with the restart of the Saldanha work operations. Currently, there are 13 direct employees and 5 indirect contract employees, with it being under care and maintenance. The reopening will result in 260 people being employed by AMSA and another 375 direct permanent on-site contractors. The 3-year period will make it possible for AMSA Saldanha Works to restart its operations and being globally competitive and to allow for certainty within the steel industry. The application was assessed using the parameters outlined on page 11 of the RFD. And it is recommended that the Electricity Subcommittee recommends to the energy regulator to approve the decision and reason for decision for 3-year NPA with AMSA Saldanha Works situated in the Eastern Cape, and to share the decision with Eskom and publish it on the NERSA website. Thank you, Chair.
Thank you, Ms. Matlo. Members, you have the submission before you. Any questions, clarity, comments? If none, members, can I then take you to the decision that is sought?
Sorry, Chairperson.
Yes, Madam Masetti.
Sorry, I've got a poor network. I think I couldn't hear Ms. Kwena. She was still presenting when I missed part of what she was saying, but I do have a question, Chairperson.
Please go ahead, ma'am.
Thank you very much. Chairperson, I just want to understand whether there are any sort of performance indicators that will give us some assurance that this applicant or ArcelorMittal will be in a position to come out of this agreement, negotiated price, with Eskom after 3 years, given the problems, the commercial problems that arise from the price that it is paying currently, just to understand that the 3-year period that is stated here, it will give us comfort, and we must also from our side progressively look into the performance and the improvement and get assurance that indeed there are certain performance indicators that will give us that comfort that come 3 years, indeed ArcelorMittal will be in a position to come out of this arrangement. That is the question that I have, Chairperson. Thank you.
Thank you, Madam Massetti. Mr. Mkhize? Mr. Mkhize, your hand is up, sir. We are on mute.
Apologies, Chairperson. I was struggling to unmute. I was under load shedding, and the electricity is just back now. I just want to ask one question. When I look at the issue of the tariff, I think it's 5.10. For 5.10, I just would like to know as to, are there no other reopeners for the review of the special tariff for this duration that maybe are worth highlighting, so that one maybe has got some comfort in terms of any changes in the landscape or whatever that might serve to as a reopener in with regard to this tariff. That's all from my side.
Thank you, Mr. Mkhize. Ms. Mato, can I hand it back to you? Advocate, by the way, I think also if my electricity comes back, I will probably be monetarily cut out, so you'll then assist. I'm also on load shedding. Ms. Matlo, over to you, ma'am.
Okay, thanks, Chair. I will request the NPA team to assist on some of the response. And with regards to the question by Ms. Massetti, we are certain that after the AMSA Saldanha works will be sustainable, because even now, even though they are still under care and maintenance, there are some of the employees that are still working. And once this is approved, and then they will implement the special tariff 6 after the approval. And another thing to consider is on table 2, where it talks the impact in terms of AMSA contribution to the economy. It shows there are some downstream industries, it has some contribution in terms of the downstream and the upstream industries. That clearly shows that once the special tariff is approved, they will be operational and they will be sustainable. With regards to the question that was raised by Mr. Mkhize, I'll ask my colleague Samson to assist and other colleagues. Thank you.
Thank you, Ms. Matlo, and morning to Chairperson, members, and colleagues. When it comes to reopener, the contract itself, even the framework, indicate that should there be a hardship, the two parties need to go back to the discussion table and see if they can come up with a better way of doing business. But if the hardship continues, then they have no choice but to terminate the contract, as it happened with silicon smelters previously. Thank you, Chairperson.
Thank you. Madam Akuban, do you want to talk, want to add, there's a point you raised on the chat, you want to talk to that?
Thanks, Chair. It was just to add in terms of what Mr. Modisa has indicated, that 7.11 outlines the risk mitigation clauses that are in the agreement. So issues of hardship. So it specifies how do either parties then indicate whether the agreement is still workable. It also talks of windfall profits, as well as cost of supply increases, etc. So there are clauses that specify the sustainability of the agreement for both parties. Chair,
thank you, Madam Akubane. Ms. Massetti, I see you've got a follow-up.
Yes, Chairperson, I do have a follow-up. I think Ms. Matlo talked about the benefits to the economy. I think it is important because regulation is also firstly about checking the performance in the industries before you go to the macroeconomic benefits, because you might not be able to measure those directly. So you might have to start from the industrial or the microeconomics benefits before you get to the macro. So I would have wanted a situation where the emphasis is put on the on how the industry will benefit from this from this arrangement, number one, and number two, that question that I've asked seeks to understand from a commercial operations perspective, what are the performance indicators that will give us comfort that indeed this arrangement would have assisted ArcelorMittal in these 3 years to be able to correct or be in a position to come out of this arrangement after 3 years. So there must be some indicators showing that indeed 3 years is sufficient. We will look into these kind of things from the commercial operations perspective, apart from just the sort of the industrial performance or the impact in the industry or the macroeconomic impact. So I thought I must just clarify these things because these things are very different from each other. So that's the kind of thing that I was looking for, Chairperson. So she could have just perhaps indicated those categories starting from the commercial operations, which is the reason why they really needed this kind of intervention and this this negotiated tariff so that they can improve and be in a position to be sustainable. That's number one. So what is it that is going to show that they will be sustainable getting into these 3 years? And then secondly, when you prove you want to show some economic impact, you then begin with the microeconomic impact before you go broadly to macro, because you're not going to be in a position to do any measurement of the macro without the micro, which is very important for our perspective, for our purpose as the economic regulator that has the mandate to deal with macroeconomic issues, industrial economics. Thank you, Chair.
Thank you, Madam. Maybe can I just assist a little bit here? I think Ms. Matlo and also Ms. Makubani, and I think to yourself also, Mr. Mdise, the issue that's asked by Mr. Mkhize is when we talk about reopeners. For instance, if there's a change in law, if there's a change in the pricing system, if there's there will be those things. Are those things not catered for in this agreement? Because if there is a change in something that may affect this, are there those off-ramps? Are there those reopeners? So that is something that I think you need to take it back to Eskom as well, and AMSA, so that in their agreement they should take that into account, because change is inevitable. Who knows what's going to happen in 3 years, within the next 3 years. So that was, I think, the essence of Mr. Mkhize's question, if I got it correctly. But the major one is most likely going to be the change in the pricing system. If the change in the pricing system happens, would it not, trigger a reopener in terms of this agreement? But it could be a change in law. It could be a change. There are all sorts of changes that are actually imminent. You've captured one, which is about the unbundling of Eskom, but that's not the only change. So that's the first one. But Madam Masiti, I just wanted to add on this one that it's something that I think as the team, perhaps at this stage, it's something that the team perhaps does not have, the information that we would not have. I mean, what the question you're asking about is, and I'm not sure whether this one is confidential as well in terms of the figure, but we know the contribution of electricity in terms of the costs structure of running a stainless steel industry. But the stainless steel industry itself is a commodity, highly competitive. Within the next 2 years, we don't know what the price of how the price of stainless steel is going to move, and it's a boom and bust industry. So in fact, it tends to be a leader, a leading indicator in terms of a recession. It's the first one that goes. The prices fall out of the bottom comes out. So with that, when that happens, it's only the most the ones that are in the first quadrant in terms of production that stay in production. So is AMSA in that quadrant? The answer to that is no. So there's a whole lot of things that the team, the information that we still need to collect on issues like that we will be able to answer the question you are asking. So I thought I'll add there, Madam Maseti. The question is clear. Would this benefit sustain AMSA? And the answer that unfortunately is not just the costs, but it's also the behavior of the market, because it's in the commodities market, and stainless steel industry is highly competitive. Mr. Mkhize, follow-up question, sir?
Thank you very much, Chairperson, and thanks for the responses. Because if you look at the 7.1, or let's say 7.11, the 7.11.1, I think that should be corrected to be table 7, by the way. Table 7 does indicate the risks, and then we'll talk to, I think, the last portion when it comes to revenue recovery certainty, when it talks to changes to the NPA framework or legislation. They can just maybe broaden that. And the question from my side was also mainly from a side of who initiates, because it seems like the two parties are the ones that must initiate. So from our side, we'll just stand by and wait for them to initiate. I was looking at a situation where we've got an option to be the first mover when we observe certain things and require of them to apply for a review of some kind. That is the issue that was not coming out that clear for me, whether we can just nudge them or we can require of them to do that. So that was the only thing that I wanted clarity on with regard to reopening. Thank you.
Thank you, Mr. Mkhize, for the clarity. That was for enhancement, colleagues. I think that is very well explained. I'm not sure if there are any other questions, or maybe Ms. Matro, do you still want to add anything?
Not really, Chair, unless if my colleagues they want to add.
Thank you. Thank you, Ms. Matlo. With that, colleagues, if there are no further questions, can I then take you to the decision that is sought? The decision that is sought is I'm not sure, Mr. Sichotlo, do you want to say something based on the comments on the chat?
No, Chair, I was actually going to suggest that in terms of the reopener, can we then approve and then put that as a condition that should anything change, and then we can then say we have a right to relook at this.
Right. Okay. So basically, that would be an enhancement and also a proposal that would then be made to the because the issue here is that the energy regulator we are proposed, the ELS can only recommend to the energy to the energy regulator. So there is time to actually make those changes that have been proposed by members, both to the RFD and also, I guess, also comments that can be made to or suggestions that can be made to both ESCOM as well as AMSA. I see your hand is up, Madam Maseti.
Thank you, Chairperson. Chairperson, I have put my points there, but I think it's something that then the team might look at. I wasn't looking necessarily for the actual evidence of that price, but at least something that will say when we make this decision, and approve, at least there are some indicators, things that we must look at, whether it's going to be cost, whether it's going to be this, and so that those are the things that we're going to monitor and evaluate during the duration of this arrangement. So those are the key things that I wanted just to see in terms of the performance indicators that will at least help us to be much more focused on the things that we must look out for as we monitor the implementation of this arrangement. That's exactly what I was looking for. But I guess maybe they can do that when they come up with the progress report on a 6-monthly basis, if they don't have that information right now or they haven't thought about it. And then the second one, Chairperson, is whether we do want to state upfront the reopener. Because if we want to accommodate a reopener, we must balance that with regulatory certainty. Because then, and also who's going to initiate that reopener? Because sometimes as regulators, we get criticized when we see that there are certain changes, things are happening, and we have already allowed the parties, to enjoy a particular price, and then things change, and then we're going to be the ones that again are going to ask that things be done differently, or and then we initiate the process, the reopener process. So we just need to think carefully about the implications of that, as well as the issue of being criticized on the basis of regulatory risk or regulatory uncertainty. So that's number one. So in the event that we consider including any clause regarding a reopener, it means we must therefore set out upfront what is going to be the criteria so that there is predictability and transparency. Everybody would know that for a reopener to be entertained, there will have to be these things that must be fulfilled. Other than that, Chairperson, I don't think that we can have just a reopener without it being accompanied by a certain criteria, objective criteria, and that criteria being justified by certain principles. So that's just my view, Chairperson. I'm not saying that it should not be done, but I'm just cautioning on the basis of the risk, regulatory risk, as well as regulatory certainty that is important from our side. And if we were to accommodate it, then it means there must be a criteria that is put out there for everybody to know so that there is predictability. Thank you, Chair.
Thank you, Madam Massetti. I see your hand is up, Mrs. Chotla. Before I put the matter before the members, in terms of an outline, the actual decision that perhaps the members can make.
Yes, Chairperson, I don't want to belay the conversation, but can I then suggest that between now and the ER, can we then, as a team, look at what criteria we can put forward, and then members can consider it at the board?
All right. No, thanks, Mr. Chotlo. Members, the decision that is sought is on page 5 of 50, page 5 of the submission. Mr. Chotlo, your hand is still up. Kindly lower it unless you still want to say something. It's on paragraph 12, but would like to then add on to this is that I think there's been a lot of suggestions in terms of enhancement, and we do have time between now and the next ER. Is that if we can then maybe request the team to enhance the RFD in accordance with all of the in accordance with all of the suggestions that you've made, members. And that may include actually engaging with both ESCOM and also AMSA, and then make those those enhancements, including the issues that has been raised by Mr. Mkhize, while he's saying that in respect of the reopeners, he is satisfied. I think also the issue of, even with the changes in law and whatever, and the pricing, I think that is also taken care of by that table. Thanks, Mr. Mkhize. But I'm just suggesting that whatever other enhancements, especially in terms of the key performance indicators, all of the issues have been raised by members, some of them that are on the chart. Can we then make the decision, but subject to the team actually making those enhancements before the document comes before the energy regulator? So, members, if I can then direct you to the decision on page 5, paragraph 12, with those enhancements that have been proposed, members, can I see by show of hands if we can approve and recommend to the ER? Thank you, Madam Massetti. Thank you, Mr. Mkhize. Thank you, Advocate Sithole. I also support. Ms. Matlo, you've got your decision. Then can we, before we go to item 12, if we can then, Mr. Mateja, if we can stop the live streaming, please.